In this video submission, we can confirm that we use AI tools like Grammarly, ChatGPT, Copilot for the purpose to enhance our understanding and correct grammatical errors and finding relevant cases. All the judgments and reasoning in this video are originally from our discussions and what we have already learned in the class.
Assalamualaikum and good morning to everybody. My name is Muhammad Syakir Ayu, reporting live from the Court of Appeal in Shah. Today, the court will hearing the case of Inspektor Muhammad Yusof bin Jahaya and others versus Chin Hock and others. The main issue in this case is whether the parties involved can be held legally liable for the matters before the court as the proceedings unfold. We will be closely following the arguments from both sides and the questions raised by the judges. Stay tuned for our live update that we will bring you from the court. Thank you.
On 1st February 2001, the plaintiffs, who were siblings and partners of a jewellery shop, were robbed by 5 men. All 5 were later arrested. On 4th February, the suspects were charged in the Klang Sessions Court under Section 395 and 397 of the Penal Code. The next day, the first plaintiff and the insurer's representative identified the recovered item at the Banting Police Station. 58 pieces weighing 1,436.17 grams of pure gold. Criminal proceedings then continued 4 years. In April 2012, the plaintiffs applied under Section 413 of the Criminal Proceeding Code to retrieve the seized jewellery. But during the hearing, they denied the item were theirs, claiming the jewellery was gold-plated and heavier, and later lodged a police report. On 31st May 2018, they filed the present suit. The Sessions Court found that the plaintiff had breached their duty and ordered damages based on the current gold price.
Yeah, Arif, the first issue is whether the plaintiff have pleaded a cause of action against the defendant. In their statement of claim, they did not clearly plead for negligence. A cause of action must be pleaded, not to be introduced later. This shows that this case is flawed from the start and should be dismissed immediately.
Young Arif, the appellant submit that there was no cause of action, which we totally disagree because in the paragraph 4 of the reply, the plaintiff stated that officers failed to ensure the safe custody of the jewellery. They satisfy the requirement under Order 18 of this Rule of Court. Therefore, the cause of action is properly pleaded.
The second issue is whether the defendant owed a duty of care and whether there was a breach of its duty. We accept that police have the duty of care to keep seized property safe under the Section 413 Clause 5 of Criminal Procedure Code. But there is no evidence of us breaching the duty. The jewellery was handled properly, and the plaintiff waited for 11 years to raise concerns. Such long delay shows that the real risk of misrecollection, not the negligence from the police.
Under Section 413 Clause 5 Criminal Procedure Code, the police are legally required to keep the seized item in a safe and proper place. This establishes a statutory duty of care, and the appellants obviously cannot deny a duty that is expressly provided in law.
Whether the plaintiff have proved their case merely because the defendant failed to prove the defense. In this case, the burden of proof should be on the plaintiff, not on the defendant. The court wrongly assumed we are liable for everything just because we could not explain everything. For example, the missing book of record and the torn envelope. That is just not how it works because suspicion does not equal to proof.
Yeah, Arif, the items produced in 2012 were not the same with the items recovered in 2001. The respondents identified pure gold jewellery in 2001, but the items produced in 2012 were, first of all, a gold-plated copper and not pure gold. Second one, 57 items instead of 58 items. The third one, 1,518 grams instead of 1,436 grams pure gold. And the chemist also confirmed the items were not in pure gold. Therefore, the police clearly failed to protect the original exhibits. Therefore, the plaintiff proved their case on the balance of probabilities.
The last issue is whether the court can decide quantum without the evidence from the plaintiff. The court awarded damages without any evidence. There was no expert testimony, no documents, nothing. The court only used an online website to determine the price of gold, and that is not how damages should be assessed.
Young Arif, the damages were properly assessed, and this is because the plaintiff lost the jewellery permanently in 2012, when it was confirmed that the items were not theirs. Thus, compensation using the 2012 gold price was reasonable, especially when the appellants provided no evidence to dispute that price. The Sessions Court did not err in awarding 249,893 ringgit and 58 cents. The appellants failed to show any appellable error by the Sessions Court. The findings were based on strong evidence and proper legal principles. We respectfully pray that the appeal will be dismissed with cause.
So in this case, I am satisfied that the plaintiffs did plead negligence. Although not expressly through the statement of claim, which is also seen, the reply dated in 21 September 2018 clearly asserted that negligence in safekeeping of the jewellery. So the defendants were never prejudiced and fully understood that the case they had to meet, and the pleadings are therefore sufficient. So I therefore here in this case hold that a proper cause of action in negligence was pleaded. As for the second issue, under Section 413 Clause 5 in the CPC, the police have a statutory duty to keep the seized item safe. So the evidence shows that it clearly breaches, which is the first one, discrepancies in the number and weight of the jewelry. So the second one, the chemist findings that the 2012 exhibits were gold-plated copper. And the third one, poor chain of custody management. So on a balance of probabilities, the defendants failed to safeguard the plaintiff's property. So it is to be held that the duty was breached. So I therefore find that the defendants breached their duty of care in this case. It is my regret to say that in this issue, this argument should be misconvinced because the plaintiff succeeded on the strength of their own positive and credible evidence. So corroborated by documents and also scientific analysis. So the session court did not find liability by default. So I therefore hold that this issue does not arise in favor of the defendants. For the final issue, the plaintiff sought general damages for loss of jewelry. The session court relied on the 2012 market price of gold for the quantity of loss. So although not the best evidence, it was reasonable in the absence of contradiction by the defendants and given that the undisputed weight of the jewelry. So the court was entitled to assess damages on that basis. So in this case, courts are permitted to make reasonable inferences in assessing general damages, particularly when the defendant's own negligence has created evidential gaps. So I therefore find that the session court was entitled to assess quantum in the manner that it did, and the award of 249,893 ringgit and 58 cents should not be disturbed. The appeal dismissed.
Now, after reading the case, we can conclude that we are supporting the decision of the court according to the two principles of negligence. The first one is duty of care, and the second one is breach of duty. The duty of care in the judgment already existed, where the police officer must keep any things to be used in the commission of an offence is required be in the safe custody of the police to investigations. It's already written in the subsection 413(5) in criminal procedure code. That's why the primary issue that the Court of Appeal emphasizes here is not whether the existence of duty of care of the defendant exists, but instead whether the defendant had breached the duty of care. Next, the breach of duty. The breach of duty, we are using the professional standard of care, which is the standard of professional must be in accordance with the standard of a reasonably competent practitioner in the field. So in this case, we refer to the case of Bolem and Friend Hospital Management Committee. It established the duty of care to the professionals. The decision of the court held that the professional practice will not hold negligence if the act is in accordance with a practice accepted as a proper but a reasonable body of medicals. Even though this is about a medical negligence, but it can be applied to the professional practitioner, like authority here is police officer. Prior to this case, the police officer here is the professional authority in handling criminal cases with a statutory duty rooted in the criminal procedure codes. The breach of duty here occurred when the defendant failed to keep the exhibits in the storeroom. Instead, he kept it in the steel cabinet. Other than that, the failure to produce the register book to the record jewelry recovered as material, and also the discrepancy in the weight of the exhibit and its composition is not the standard of care that a reasonable policeman would do. In conclusion, we are supporting the decisions of the court as it clearly shows the breach of duty by the appellant. Now, we're moving on to the comparison with other relevant cases. The first one is the case of Tan Wing Hong and others, and Malaysia Airline System, DHT, and others. So basically, the plaintiff, including the child, which is the minor, sued Malaysian Airlines pertaining the case of disappearance of MH370. The court decision that might still liable under the Montreal Convention due to the failure to track and protect the passengers. The case is about Majlis Pemadaran Ampang Jaya and Stephen Paul Cheng. So basically, it's about the case about the Highland Tower collapse. So the residents sued Majlis Pemadaran Ampang Jaya for negligence after being evacuated and suffering economic loss. So the plaintiff claimed Majlis Pemadaran Ampang Jaya failed to maintain drainage and slopes, which is contributed to the collapse. This is here, MPA is the public authority has a duty of care as the harm was possible and the proximity existed as the authority who is in charge in that area. So the breach of duty occurred due to the failure of procedural conduct according to the standards of practices. Compared with this case was Malaysia Airline System and Majlis Pemadaran Ampang Jaya, both is a public authority which also take on a duty of care. Here, the Malaysia Airline System failed to conduct under the Montreal Convention due to the failure to track and protect the passengers, while Majlis Pemadaran Ampang Jaya failure of procedural conduct according to the standard of practices. While comparison to the case, the public authority, which is the police officer here, on the duty of care to keep the exhibit under the custody safely according to the section 413(5) criminal procedure code. So the breach of duty occurred when the failure of the defendant to keep the jewelry safely during the custody. Impacts of the decisions for the future cases. The first one is imposing the stricter criminal procedure codes for the authorities and the public officers in making sure that there's no negligence in handling the exhibits or register book. And the second one is vicarious liability to the governments of Malaysia, which is they might be held liable for the negligence due to the negligence made by police officers, which is a part of the government institution.